sufficiency in substance, which should contain narration of facts. The definition of facts, it must be distinguished from bare allegations, because bare allegations are not evidence. We should concentrate on whether or not, yes, we have to deal on the four corners of the complaint, but we should see if there are narration of facts which are not bare allegations which can possibly lead to a proof that there is constitutional violation which is an impeachable offense. Madam Chair, Your Honor. So I do not agree that just allegations will be considered to determine sufficiency in substance. I
Madam
respectfully submit.
Of Section 5 of our Rules of Impeachment, it says, determination of sufficiency of substance. It's not acceptance of a recital. The word determination, it bears emphasizing that it is upon the responsibility of this committee not simply to accept a recital in an impeachment complaint. We have the duty to determine it with diligence. And it is not acceptance merely of allegations. It is determination of facts which should at this stage be at least supported to determine whether there is sufficient or probable cause that will be further heard in the proper hearing by this committee. So it is only proper that the recital of facts should at this stage be at least supported by evidence for us to declare that the complaint is sufficient, not only in form, but also in substance. Thank you, Madam Chairman.
Thank you. Madam Chair. The Honorable De Lima, and then Honorable Co, and then Honorable Tino, and then Honorable Garbin. Okay, one after the other. And then Honorable Rodriguez. The Honorable De Lima is recognized.
Thank you, Madam Chair. Good morning, everyone. Technically and strictly, and if we go by the standard set of the House rules itself, the rules of procedure in impeachment proceedings, it's supposed to be just, we just have to look at whether the complaint has a recital of facts constituting the impeachable offense charged and determinative of the jurisdiction of this committee. I don't think there's any issue on the jurisdiction. This committee has jurisdiction. Now, the recital of facts constitutive of impeachable offense charge, in addition to what has been articulated earlier by the Honorable Chairperson about, it must not be based on conclusions. I would wish to further elaborate on exactly what sufficiency in substance mean. When we talk about substance, it refers to whether the complaint alleges ultimate facts that, if hypothetically admitted, would constitute an impeachable offense. So hypothetical admission lang. Hindi pa natin titingnan kung totoo o hindi, o may supporting evidence ang isang allegation of fact. And as I said, in addition to the standards set in our own rules of impeachment, rules in impeachment proceedings, a complaint is sufficient in substance when it, number one, narrates specific acts or omissions, not mere conclusions. Number two, it shows a nexus, a connection between the acts complained of and an impeachable ground. Kailangan konektado yung mga allegations of facts doon sa constitutional ground. Number three, should be intelligible and coherent, allowing the respondent to meaningfully answer. Number four, it's not purely speculative or opinion-based. And then, pwede rin, in terms of just checking the sufficiency of the entire complaint, whether we can also look into whether it's supported by annexes or references, although proof need not yet be conclusive. Dahil nga po, evidence is not weighed at this stage. The test is allegational sufficiency, not credibility or truth. Yun po ang aking position. Thank you very much.
Thank you, Honorable De Lima. Now we recognize the Honorable Ko.
Thank you, Madam Chair. Good morning to the committee. Once again, I also submit and I agree with the manifestation made by Representative De Lima. And I would just like to add further in regard to the discussion on ultimate facts. Given that actually the rules of court supportorily applies to the rules on impeachment under Section 19, I'd like to read Rule 8 of the Rules of Court of the Philippines, wherein it says that pleadings are required to set forth ultimate facts on which the party relies for a claim or defense. And as stated earlier, the ultimate facts are generally what is the allegation of the offense, the acts or omissions, and how it relates to the offense charge. That's different from evidentiary facts, which is not required to be included in a pleading yet, and that can come later on when we enter the hearing proper. And it's different also from conclusions of law. So right now, what is on the floor is the determination whether the ultimate facts are alleged in the pleading. And so given that we're at this stage right now, we will determine whether the complaints are sufficient in substance as to whether ultimate facts alleging the offense charged is sufficient for this body. That's all. Thank you.
For the guidance of all the members, our parliamentary status, we are determining whether or not the question of personal knowledge and authentic records, specifically with respect to the attachments, should be considered in the determination of sufficiency in substance. Moving forward, we now recognize the Honorable Tino.
Thank you, Madam Chair. The Honorable De Lima and Ko, they have eloquently made the point that at this stage, this committee is not supposed to determine facts. This is not the proper stage for that. That will involve the hearing proper. So at this point, the complaints may be determined as sufficient in substance if they are found to allege facts that constitute a ground for impeachment. Hanggang dun lang po. Hindi pa po natin papasukin kung totoo ba talaga o hindi yung mga allegations sa complaint. Yun lang po, Madam Chair. And as to the question of authentic records and so on, my position there is that dapat tinanong yun kahapon. Dahil yun yung precisely, yun yung inaalam, whether or not the verification requirement was satisfied. At ang sinasabi dun sa verification that the complaint is based on personal knowledge and or authentic records. And that has already been settled by the committee. Thank you, Madam Chair.
Thank you, Honorable Tino. Now we recognize the Honorable Garbin.
Thank you, Madam Chair. We are all guided here by the rules of impeachment of this House. And the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. The complaint before us, filed against the President, alleging impeachable offenses, namely culpable violation of the Constitution. Major allegations by category is the surrender of former President Rodrigo Roa Duterte to the ICC. It is noteworthy to mention, Madam Chair, and to this honorable committee, that the case before the Supreme Court questioning the constitutionality of the said alleged surrender and kidnapping, case of GR number 278762 in the matter of the petition for the writ of habeas corpus of Rodrigo Roa Duterte is still pending. In fact, the status of the case right now is that parties were required to file position papers. And so, therefore, Madam Chair, to my mind, these are mere conclusions, not established facts, Madam Chair. And later, I will manifest my findings on the major allegations such as the culpable violation of the Constitution, and will declare my vote and explanation to my vote, Madam Chair. Thank you.
While the opinion of the Honorable Garbin on the first offense is significant, we will be holding our discussion on the first offense until we thresh out the question on whether or not we will consider the attachment if they are authentic record for the purpose of determining sufficiency in substance. That is our parliamentary state right now. The Honorable Rodriguez.
Madam Chair, after hearing the discussions, I am fully satisfied.
So before we proceed to our discussion on the offense, that is kidnapping, we wish to thank the significant views and opinions as to the question of whether or not the attachments should be considered for the purpose of determining sufficiency in substance, no? And I understand that there are varying opinions. Some members would say or said that they should not be considered and we should stick on what are stated in the impeachment complaints, while some would say that they are necessary for the purpose of determining the substance or the sufficiency in substance. The chair wishes to elicit a motion as to whether or not we will include the attachment if they are authentic records for the purpose of determining sufficiency in substance as a preliminary matter.
Madam Chair.
The Honorable Ko.
Okay. Madam Chair, I move that for this portion of the discussion, the body contemplates whether the facts alleged in the complaints constitute the offense charged. And at this stage, we do not need yet to cross-check or check it whether it is supported by the evidence, be it based on personal knowledge or authentic records. I so move, Madam Chair.
Madam Chair,
The Honorable Rodriguez.
point of order.
The Honorable Rodriguez is
The
recognized.
Honorable Ko is a party of the case as the endorser also in these particular proceedings. And so therefore, we will request all the endorsers that in the deliberation of the committee, they cannot participate. This is a proceeding akin to a preliminary investigation. And so the complainant and their lawyers would not be the one moving to the prosecution to proceed with the case. And so therefore, with due respect, let us allow our members, and of course, we will appreciate you at the proper time in the discussions to elaborate further the complaints. But as already parties, the party is the De Jesus complained, Attorney De Jesus, and Jet Nisay, the endorser. Masa, the three respected gentlemen and lady. And so, the other party is the President, President Ferdinand Bongbong Marcos. And we are the committee investigating. So therefore, let us wait for another member to move whatever is the motion about. So I would like to seek the ruling of the chair.
Would you like to comment to that, Honorable Ko, before we rule?
Okay. Thank you, Madam Chair, Honorable Rodriguez. While I understand the logic of the manifestation, we'd just like to manifest that the three complainants of the second impeachment complaint are members of the Committee on Justice. So again, we also respectfully seek the ruling of the chair in regards to this matter, whether or not we can participate in the deliberations of the discussion on the first impeachment complaint, because as at least provided by the rules, it is a right that is provided upon the members of the Committee on Justice. Thank you, Madam Chair.
The chair recognizes the right of each member of this committee, notwithstanding his dual capacity of being an endorser as well. So, in resolution of the question as to the capacity of the Honorable Ko to raise a motion, the chair rules in favor of the authority and right of the member, notwithstanding the fact that she is an endorser as well, to raise the necessary motion.
But Madam Chair,
Before that, Madam Chair, we respect that ruling. Would therefore, in the voting of these two complaints, will Representative Ko be voting?
To the honorable members of this committee, we are exercising a very important process, and it is not the intention of this committee to impair whatever right and authority each of the member has in this committee. So if we are upholding the right of a member who is at the same time an endorser to raise a motion, we are likewise upholding her right to vote on the motion. Honorable Ko?
Madam Chair, before I answer, perhaps in the order also of the matters, given that we'd like to thank the Madam Chair on the ruling, but in deference on the discussions, I'd like to retract my motion and would allow the body to make that motion, given that there's this question. But nonetheless, we, as a member and in deference to the ruling of the chair, we will continue to participate in the discussions.
The chair has ruled already.
Okay.
The motion by the Honorable Ko is
Sustained.
upheld by the chair.
Okay.
So I will just be requesting for the rephrasing of the motion, because it should not entail the evidence aspect of the attachment. The question only is whether or not the attachments as authentic records should be considered for the purpose of determination of sufficiency in substance. We are not yet on evidence. The Honorable De Lima is recognized.
Given the withdrawal by the Honorable Rene Ko of her earlier motion, may I therefore make this motion? I move to exclude in the consideration of sufficiency in substance the determination of the authenticity of authentic records, if any, as attached to the complaint.
There
Do not
is,
consider.
there is a motion to exclude the authenticity of the attachments for the purpose of the determination of sufficiency in substance. Do I hear a second? Is there any objection?
I object, Madam Chair.
The motion has been objected to. We shall now divide the House. Those who are in favor of the motion, please raise your right hand. For the guidance of everyone, the motion is to exclude the authentic record constituting of the attachment for the purpose of the determination of sufficiency in substance. Those who are in favor of the exclusion of the attachment, please raise your right hand. You may put down your hands.
Madam Chair.
Let the chair restate the motion. The motion is to exclude the issue of authenticity of attachments for the purpose of determination of sufficiency in substance. In other words, whether we exclude or not. So if you vote in favor, we exclude the issue of authenticity of attachments. If you don't vote in favor, then we discuss on the issue of authenticity of attachments.
Chair,
The Honorable Tino.
may I clarify that the exclusion of the determination of authenticity is only for this stage, no? Because the position is
Of
that
course.
that should properly be done in the proceedings proper.
Correct.
Not at the stage of determination of sufficiency in substance. Para malinaw lang po, kasi baka isipin na yung motion ay ayaw na ma-determine kung authentic ba yung records o hindi. Ang sinasabi lang po, hindi po ito ang tamang panahon para
Correct.
gawin yun.
Okay.
May I be recognized, Madam Chair?
The Honorable SDML is recognized.
Just for purposes of determination of sufficiency of substance, I vote not to exclude. I vote to include.
That's
Kasi baka merong mga impeachment complaint na wala naman palang attachment o hawsyaw ang mga attachment. I am not saying na we will discuss the contents of the attachment. That would be for the proper hearing after we determine the substance. Ang sinasabi ko lang, dapat kapag may recital of facts, ang naka-attach dito ay mga dokumento na may probative value naman for proper hearing para hindi hawsyaw o haka-haka lang ang recital of facts.
Madam
I
Chair,
submit, Madam Chair.
Madam Chair.
The
Madam Chair.
Honorable Keith Flores.
Madam Chair, at this point, Madam Chair, I think it's enough that we rely on the verification under oath by the complainants themselves that it is based on true and correct facts and that it is also based on authentic records. Under oath, Madam Chair.
Madam Chair.
The Honorable Redon.
To be very clear po, I am only pertaining to the first impeachment complaint, and it's actually it's just a factual question. Which of the attachments are in fact certified through copies, no? Gusto lang ho namin malaman. We are not conflating this question on whether or not this proceeding should in fact even proceed. Kasi sa totoo lang, kahapon po, I was raising it already in the determination of form na in fact in previous impeachment proceedings an impeachment was denied, rejected by the committee on the basis of the absence of personal knowledge and authentic records on the question of sufficiency in form. So ibig ko sabihin, if we will not be allowed to determine this at this point, kailan pa ho natin yun madedetermine, hindi ba? So, yun lang ho actually, and it's not even my question. My question is basically just factual. Doon po sa first impeachment complaint, alin po doon sa attachment, yung sa totoo lang, certified true copy, at alin po doon sa mga yun, yung hindi. Without conflating it onto whether or not this complaint should proceed.
Madam Chair,
Honorable Rodriguez.
we are not yet there. We are still, the requirement really is just recital of facts, ultimate facts. In fact, the annexes are really would pertain to what is stated in the complaint. That is why it's annexed. We cannot go to the annex now because we are only, according to the rules, only focus on the recital of facts constituting the offense, and the complainant should be able to put in that complaint, in the recital of facts, what are the basis why the respondent will be liable under the 6 grounds provided by the Constitution. And that is why we don't yet go to the annexes. They are already mentioned in the complaint, because otherwise the annex standing alone cannot stand. It is to enforce a statement of fact in the complaint. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. For the guidance of all the members, we've heard a lot of varying opinions. Some are in favor of excluding the attachments for the purpose of determination of sufficiency in substance. Some are not in favor. But for the guidance of everyone, before we proceed to voting, we are requesting the Honorable De Lima to restate the motion.
Thank you, Madam Chair. I move to exclude the determination of the authenticity of the annexes, the records as attached to the complaint, at this stage of the proceedings, which is the determination of sufficiency in substance.
All right, the same has been seconded, and the same motion was objected to by the Honorable Ridon, and that is now, we are now dividing the House. Those who are in favor of the motion is to exclude. Raise your right hand. You may put down your hands. Those who are against the motion, please raise your right hand. You may put down your hands. Those who abstain, please raise your right hand.
Madam Chair, can I just say my...
Please wait, Vice Chair Dumogan, until we resolve the motion. Can we have the number of votes? Let me reconfirm. I find the numbers a bit doubtful. Okay. The motion, again, is to exclude the determination of authenticity of attachment for the purpose of determining sufficiency in substance. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. With 21 in favor of the motion and 24 against the motion, the chair declares not to exclude the authenticity of the attachment in the determination of sufficiency in substance. So ruled.
Madam Chair? Madam Chair?
Madam Chair.
Madam Chair?
Can I call first Vice Chair Dumogan?
Thank
Vice
you.
Chair Dumogan and then Honorable Tino. You're
Just very
recognized.
short. Thank you, Madam Chair. I'm happy that we voted against the motion because if we voted in favor of that motion, it will be violative of Section 3. The Section 3 requires, based on authentic records, in all of a sudden, in the determination of sufficiency in substance, you will waive the determination of authenticity of document. It's violative of Section 3.
Thank you,
Madam
Vice Chair Dumogan. The Honorable Tino?
Madam Chair.
The Honorable Tino.
Thank you, Madam Chair. Madam Chair, in view of the fact that the chair herself had to call for a vote 3 times, and in the second instance, she even commented on the record na hindi siya makapaliwana sa resulta. Okay? So in other words, medyo wala pong clarity dun sa naging botohan. I move for nominal voting on the point, Madam Chair.
The Honorable Flores is recognized.
Madam Chair, Congressman Tino, I saw the numbers admitted by the Secretariat. We lost on both counts, sir.
Let us be reminded that this is just a preliminary matter, no? I hope we will be recognizing the decision of the majority of the committee in as far as this issue is concerned.
Madam Chair.
The Honorable Ko.
Thank you, Madam Chair. Madam Chair, with due respect to the members of the committee, it is this representation's belief that hindi po actually dapat subjecto ng vote because the rule provided in the rules on impeachment proceedings that in this stage, to determine the sufficiency in substance, ang kailangan pong gawin is to determine whether there's a recital of facts constituting the offense charged. That's it.
With
And
all due
hindi po
respect,
ito
the Honorable
nakalagay
Ko,
otherwise.
the committee has ruled already. The Honorable Garbin.
Thank you, Madam Chair. I've been hearing the position of the movant, and they invoke the rules of court as in suppletory character. Now, while impeachment is a political process, the determination in sufficiency in substance is analogous to a judicial requirement that a pleading must allege ultimate facts constituting a cause of action, not mere conclusions of law or argumentative narratives. Under Rule 8, Section 1 of the Rules of Court, pleading must state the material facts relied upon and not evidence on general averments of wrongdoing. Applying this standard, Madam Chair, by analogy, the first complaint largely asserts labels and conclusions, such as the betrayal of public trust. And therefore, it is but right that the majority of the members should assert to include and determine the authenticity of the attachment in the said complaint. Thank you, Madam Chair.
The Honorable De Lima.
Just a short comment, Madam Chair.
You're recognized.
Given the vote to still include the determination of the authenticity of supporting documents or authentic records, I believe it will unnecessarily delay the proceedings and prejudice the causes of any complainant. And it went outside what the very essence of what is the determination or what is sufficiency in substance as explicitly laid down in our own rules. Tatagal po ang proceedings at unfair sa mga complainants. And labag dun sa ating rules natin. Recital of facts constituting the offense charged. So what is the point of looking into or inquiring into the authenticity of supporting documents? That's my view, Madam Chair.
Thank
very
you. The
much.
Honorable Flores.
Madam Chair, I agree with Congresswoman De Lima, and I have also seen the complaint and the attachments for the impeachment complaint against the Vice President, and it's voluminous, Madam Chair. And if we follow that rule on that impeachment complaint, it will take us forever.
Madam Chair,
The Honorable De Lima.
thank you very much, Madam Chair. In view of these views expressed post-voting, may I move for reconsideration of the decision of the majority?
For the guidance of all the members, the question of the committee right now is only with respect to whether or not the records are authentic. It doesn't go into the truthfulness of the contents of the attachments yet, which is evidentiary already, no? The motion which we voted upon only pertains to whether or not we will include the issue of authenticity of the attachments. And I think that will be answered by merely checking on whether they are certified or otherwise. We are not looking into the truthfulness of the contents of the attachments yet, because we all agree that that will happen during the hearing proper of this proceeding. So with the indulgence of all the members, we have voted upon this motion. This is merely preliminary. We have 5 grounds to discuss, 5 offenses anchored on 3 grounds to discuss. We shall now proceed to hear the comments and manifestation on the first ground. That is kidnapping and surrender of the former president constituting either culpable violation of the Constitution or betrayal of public trust.
Madam Chair.
Is this about the first offense?
It's still about the annexes, Madam Chair.
We have ruled on that issue already. So,
Madam Chair, let's
in the
proceed.
interest of time,
Let's proceed.
in the interest of time and with the indulgence of all the members, let us proceed to hear the comments and manifestations on the offenses and whether the same constitute a ground for impeachment.
All right, I just wanted to state for the record, Madam Chair, that proceeding to the first ground,
The first offense.
the first offense, most of the annexes are news articles. I'm stating it for the record. They're only, for the entire complaint, there are only, I think, 3 annexes that are official records on which I'm asking on whether or not there exists a certified true copy for it when it was submitted to the House. No? So this is Annex U, transcript of Committee on Accountability of Public Officers and Investigations, Blue Ribbon, 25 September 2025. Annex L, Supreme Court decision dated 3 December 2025, Pimentel versus House of Representatives. And Annex A, Committee Report, Committee on Foreign Relations. Everything else, Madam Chair, are actually news articles that had been submitted as attachments to this particular complaint. And I think there is particular relevancy to it because I'm quite certain that it might be insufficient for evidence to be based on mere news articles only. So going to the allegation relating to kidnapping and arresting the president and bringing him to The Hague. I think it needs to be stated, Madam Chair, that the arrest of the former president is in pursuance of a treaty obligation between the Republic of the Philippines and Interpol. So, wala pong batayan para sabihin that the former president was kidnapped. More importantly, kidnapping is a legal conclusion and it does not constitute as a statement of fact. No? So, doon pa lang po, parang meron na pong problema yung pong ground po na ito. So, to be clear, ang annex po on the matter is Annex A, Committee Report, Committee on Foreign Relations. Annex B, Senate probe reveals lapses in Duterte's arrest. Daily Tribune, 27 March 2025. Annex C, Duterte ICC arrest. Inquirer, 27 March 2025. At Annex D, VP Sara on father's arrest. GMA News Online, 20 July 2025. But I think it has already been sufficiently established, Madam Chair, that this was not a kidnapping. This was an implementation of a warrant that had been issued by the Interpol, in which Interpol sought the assistance of the Republic of the Philippines to implement this particular arrest warrant against the former president. To be clear, this is not in pursuance of a relations between the International Criminal Court and the Philippines, because this relation has already been broken when we had left the ICC in the previous government. So, para malinaw lang po, walang batayan para sabihin na meron pong pananagutan ang ehekutibo dito po sa pag-aresto sa dating Pangulo at pagdadala po sa kanya sa International Criminal Court, Madam Chair.
Madam Chair.
The committee notes the manifestation of the Honorable Ridon. The Honorable Chu is recognized.
Thank you, Madam Chair. Madam Chair, I share the observation of the Honorable Terry Ridon, and I also submit that there is insufficiency in substance for a very simple reason that we all should be guided by the elements of the crime alleged, which is kidnapping. Ano po ba para pumasok sa kidnapping? Maliwanag naman po sa ating revised penal code. Number 1, kailangan yung offender is a private individual. Dito pa lang po, wala na po, tapos na po yung usapin. Pangalawa, dapat po ay yung act, dapat po the act is illegal or the deprivation of liberty is without legal justification. Maliwanag naman po that the arrest of the former president was via warrant issued by the International Criminal Court. So dito pa lamang po sa dalawang elementong ito ng kidnapping, wala na po, kulang na po. Kaya masasabi ko po na yung offense charge will not be sufficient in substance. Thank you po, Madam Chair.
Madam Chair, may I
Thank
be
you.
recognized? Madam Chair.
The Honorable Po, and then Honorable Chel Jokno, and then Honorable De Lima. And then Honorable Vice Chair Dumogan.
Madam Chair, thank you for recognizing me. Just for clarity, would it be possible to ask the endorsers if they're aware of any kidnapping cases that were filed against any members of the administration in relation to the ICC arrest?
May we request the endorser, the Honorable Nisay, to answer the question of the Honorable Po?
Madam Chair, sagutin ko lang yung kabuuan. Attached sa DSUS complaints ang ilang dokumento o public records at pati na rin sa mga news articles kasi sila ang pinaka-accessible.
If I may interrupt, Honorable Nisay, the question is very specific. whether or not you are aware of a case of kidnapping filed against the impeachable official.
Am I aware, Madam Chair?
You are?
Aware of that.
So you are aware that there is a case of kidnapping filed against the impeachable official?
No, no, no. That there is no, ma'am.
Okay. So does that satisfy your question, Honorable Po?
Yes, Madam Chair. The reason why I asked that is because in order for us to determine that kidnapping had taken place to begin with, if there was kidnapping, shouldn't there have been a case filed against any administration official involved in the ICI arrest?
You mean not only the impeachable official?
Not only the impeachable official, because even if we're
Madam
saying
President,
responsibility-wise,
Madam Chair, the
shouldn't
President
the
is
case have
immune
been
from
filed?
suit, and therefore
That
there's
is
no
correct.
case pending before this President.
All right.
But Madam Chair, even if the President is immune from suit, no other official in the administration has a case pending regarding kidnapping.
Okay.
Am I
To
correct?
complete the question of the Honorable Po, he's asking if you're aware of any case filed against any government official in relation to the alleged kidnapping and arrest of the former president. Honorable Nisay?
Yes, Madam Chair, I am aware that no pending case.
He is aware that no cases were filed against any government official.
That's all, Madam Chair. Just wanted to establish that for the decision-making of those who will be determining substance on the grounds of kidnapping.
Thank you, Honorable Po. Honorable Jokno is recognized.
Thank you, Madam Chair. First, a point of clarification on the ruling of the chair and of the committee. Does this mean that during the next phase or the evidentiary phase of these proceedings, the complainants will not be able or will not be given the opportunity to authenticate their documents? Because I believe that that is a part of due process that should be accorded during the evidentiary phase. I am concerned because this ruling will have an effect on other impeachment complaints, that if we adhere to this and strictly apply it, that would we would be depriving complainants of their day in court. I'm very concerned about this, Madam Chair, because as I understand it, we go first through the form, which is a very simple process. We then look at the complaint in terms of sufficiency and substance, which, as Congresswoman De Lima said, is simply looking at the allegations of the complaint and hypothetically admitting that they are true. And then, only after that, do we look at the evidence and allow the parties to authenticate their documents. I don't think there's any requirement at all in our rules that require that all documents upon filing of the complaint already be duly authenticated.
The Honorable Vice Chair Dumogan.
Let us read Section 3 of our own rules. Second paragraph. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. There we are. The rules of the impeachment of the House requires that those documents to be attached must be based on authentic records. That's what I was pinpointing.
Madam Chair.
I might somewhat agree with you, but that is our own rules.
May I respond, Madam Chair? The way I understand it, that matter should have been taken up when we discussed the form in terms of whether the verification was proper or not. We have already gone past that stage. We are now looking at the sufficiency and substance of the complaint. And later, assuming it is sufficient in substance, I think we have to give the complainants the opportunity to substantiate, authenticate their submitted documents.
Madam Chair,
The Honorable Tino.
in addition to that, I would point out that the requirement on in the determination of sufficiency in substance, where it says that the complaint must be a verified complaint, meaning to say it is based on on personal knowledge and or authentic records, that requirement is satisfied through the submission of a verification duly sworn to and notarized. So for purposes of these preliminary stages of the impeachment proceeding, for as long as there is a verification duly notarized, then that requirement that this is a verified complaint has already been satisfied. Lagpas na po tayo doon.
With the
Madam Chair.
indulgence of the members of the committee, let us all be reminded that we've ruled already on the issue of the inclusion or exclusion of the issue of the authenticity of the attachments. As to the question of the Honorable Jokno, whether we will be allowing its authenticity during the reception of evidence, we reserve the discussion of that issue as we reach that matter, which is the reception of evidence during the hearing proper. We are reminding the members of the committee to confine the discussions and manifestations to the offense which is being discussed at the moment. We are on the first offense. The Honorable Padiernos.
Madam Chair, may I proceed to propound some clarifications and questions?
Is it on the first offense?
Yes, Madam Chair.
You may proceed.
I would like to address the questions to the Honorable Nisay. So, for clarity, the grounds for the first allegation is based on culpable violation of the Constitution and betrayal of public trust. Is that correct, Madam Chair?
The Honorable Nisay.
Yes, Madam Chair.
Madam Chair, may we know from the endorser which specific, in terms of the culpable violation of the Constitution, which specific provision in the Constitution did in this case, the President violate?
Representative Nisay may answer. The question is the specific provision of the Constitution which was violated by the impeachable official.
Yes, Madam Chair.
Madam Chair, can request 2 minutes break.
Of course. Let us be reminded by our understanding about the sufficiency in substance that the offense alleged we should be able to connect the offense alleged to the ground of impeachment under which the same is anchored. And I wish to believe that this is the rationale behind the question of the Honorable Padiernos, why he is asking what specific provision of the Constitution was actually violated in relation to allegation of the kidnapping and arrest of the former president. Would you like to move to your next question or manifestation while the endorser thinks over the proper answer to your question?
Madam Chair, this is very important because according to the rules of the House on impeachment, in determining the sufficiency and substance, we must determine whether there's a recital of facts constituting the offense charge. So this is very important to know which exact provision of the Constitution did the impeachable official violate.
So, Madam Chair,
You're recognized, Honorable Nisay.
under po the due process, nirerespeto po natin yung Constitution.
It is the due process clause.
In that sense, Madam Chair, would well, may we know from the endorser that whether any Philippine court has issued a finding that there was a violation of due process or that the arrest constituted kidnapping?
Madam Chair, none so far.
So in this case, Madam Chair, it would appear that on the basis of the first ground, there is no impeachable offense. And to add on to that, Madam Chair, may we know from the endorser whether there is an actual written presidential order with regard to the arrest of the former president.
Madam Chair, wala po, pero under the directive po yung ng presidente, ang PNP.
Congressman Padiernos, he's saying that the PNP was under the directive of the impeachable official, that's why. Notwithstanding lack of order coming from the president.
But again, Madam Chair, we are determining here there must be an overt act personally attributable to the president or the impeachable official. So how can we say that the impeachable official should be liable because of the supposed action of the PNP in this case?
Honorable Nisay, Honorable Padiernos is asking for the overt act committed by the president or the actual participation with regards to the alleged arrest and kidnapping.
Madam Chair, I think yung dapak po na wala siyang ginawa. Yun po yung...
So, Madam Chair, is omission equivalent to an impeachable offense?
Madam Chair, for us po, is a yes.
I rest my case, Madam Chair. I would just like to manifest that based on the answers propounded by the endorser, and with due respect, this representation does not believe that on the first ground that there is an action, there is a recital of facts that would constitute the offense charge being culpable violation of the Constitution and betrayal of public trust. That's all, Madam
The
Chair.
committee notes the manifestation and answer of the endorser.
Madam
The Honorable Suntay.
Thank you, Madam Chair. Through you, Madam Chair, on the first ground, alleged culpable violation of the Constitution, the complainant alleges that the President ordered or enabled the arrest of and surrender of the former President Rodrigo Duterte to the ICC, did so without a valid Philippine warrant, therefore violating national sovereignty, due process, and constitutional guarantees. Would that be correct?
Yes, Madam Chair.
So the legal theory asserted, Madam Chair, is that the ICC surrender constitute a constitutional violation and therefore an act of betrayal of public trust. Would that be correct?
Yes,
Honorable
Madam
Nisay.
Chair.
And may I know, Madam Chair, through you, may I know what would be the evidence to support these allegations? I was reading the complaint. I saw Senate committee reports, media articles, statement of public officials, and it was limited to that. Would there be any other?
Madam Chair, yung mga news articles, yung mga publicly available published articles. Kasi sila po yung pinaka-accessible na form ng public record na nag-reflect ng mga event timelines at statements na alam naman ng public Gaya po ng sinabi ko kanina, isa sa mga layunin ng mga news articles na ito ay mag-establish ng pattern na mayroong nangyayaring graft and corruption, culpable violation of the Constitution, betrayal of public trust. Kumbaga sila ay mga circumstantial evidence na pag nag-combine ay magpo-form sa conclusion na karapat dapat nang i-impeach ang ating presidente dahil siya ay karapat dapat hindi mamuno.
So, Madam Chair, through you. So, based on your answers on the first grounds being alleged, the only evidence are news articles and clippings. Therefore, you are attributing these actions to the President. Are there any arrest orders signed by the President?
That question has been answered already, Honorable Suntay.
Executive issuances or documentary proof of direct command?
Madam Chair, wala po.
So, does that mean that we are alleging a constitutional offense committed by the President just because the former President was the ICC was allowed to not arrest because to try the former president?
Yes po, Madam Chair.
So, Madam Chair, based on the answers of the endorser, on the first ground, on my position is that the allegations is not sufficient to form an impeachable offense on the first ground.
Okay. For the guidance of the members, we need not state our position with respect to the sufficiency. All the questions, manifestations, and comments will be taken in consideration as we vote on the entirety of the impeachment complaint with respect to the sufficiency in substance. Nonetheless, the position of the Honorable Suntay is duly noted by the committee. The Honorable Po and then the Honorable Dilima. Is this still on the first offense?
First offense, but wrapping
You may
up.
proceed.
Madam Chair, on the first offense, just to give clarity to everything that we've spoken about at the moment,
Kindly speak louder, Honorable Po.
just to give clarity on what was taken up so far, the endorser is claiming that there is a betrayal of public trust based on kidnapping, which, as we've discussed here, no cases have been filed, on a violation of due process, again, in which no cases have been filed, because of command responsibility in which the PNP was acting under the President. Again, no cases were filed against any member of the PNP for either a lack of due process or for kidnapping. So just for the members of the committee who are deciding on this matter, on the substance of the first grounds, it would be important and prudent to note that there are no cases filed as attested to by the endorser. And if our determination of betrayal of public trust is based on kidnapping, which wasn't affirmed, and betrayal of due process, I feel that this may be something we should take a closer look at, and maybe we should wrap up already on this discussion and move on to the next grounds.
Madam Chair.
The Honorable Dilima.
Thank you, Madam Chair. So we're talking about the first ground. The general ground, the general ground is culpable, or the ultimate ground is culpable violation of the Constitution and betrayal of public trust. The supposed supporting factual allegation is ordering and enabling the kidnapping and surrender of the former president to the ICC. Now, for this specific factual allegation, I point out 3 sub-allegations. One is that the former president was arrested without Philippine warrant and forcibly transferred to ICC. I say that these are insufficient allegations of facts in terms of time and date, place of occurrence, persons involved, and events that transpired. Complainant, I humbly submit, cannot presume judicial notice of sequence of events that transpired in the former president's arrest. He must allege the specific facts of the arrest relevant to this ground of impeachment and not merely a general allegation that the former president was arrested and transferred to ICC. The second sub-allegation is that allegedly PBBM resorted to foreign intervention and ignored domestic legal processes. I say that these are legal conclusions and not allegations of fact. Even if this is to be treated as factual allegations, complainant must state the specific acts laying down the conclusion that PBBM resorted to foreign intervention and disregarded domestic processes. The complaint must answer the question of what were the specific acts committed by PBBM that constituted consenting to foreign intervention and disregarding domestic legal processes. Again, the complaint cannot presume judicial notice of the events that transpired on that day. The third, the last sub-allegation of fact. PBBM surrendered the former president, FPRRD, to a foreign tribunal. I say again that this is a legal conclusion and not an allegation of fact. Even if this is to be treated as a factual allegation, the complaint must still allege the specific acts, that constitute the surrender of FPRRD to a foreign tribunal. Complaint cannot rely on judicial notice to establish the specific acts that constitute surrender to a foreign tribunal, which is in fact also debatable, especially in light of alternative versions that FPRRD was not surrendered but arrested by virtue of an ICC warrant in accordance with RA 9851. So to me, Madam Chair, the first allegation is not a sufficient allegation of fact, but mere conclusions lacking in specificity. So insufficient po para sa akin yung first ground.
Madam
Thank
Chair.
you.
Thank you, Honorable De Lima. Now we recognize the Honorable Alvarez.
Given the lengthy discussions, listening to legal luminaries
On the first offense.
of the first event of the complaint, even given that the president was there during the planning of the execution to serve the warrant, even if he committed error in judgment, is not an impeachable offense. Therefore, given that the first complaint on the Jesus complaint has no substance, Madam Chair, I move to dismiss the first complaint.
We are not
the Jesus
finished
complaint.
with our discussion of the offenses and as to whether they constitute an impeachable ground.
Therefore, I modify my motion to consider the first allegation as insufficient in substance.
Madam Chair.
We cannot entertain that motion as well because we will be deciding on the entirety of the complaint after we have deliberated upon the 5 offenses alleged in the complaint. Nonetheless, the manifestation of the Honorable Alvarez is duly noted.
Madam Chair.
Any
Just-
other manifestation, Honorable Alvarez?
I maintain my motion subject to further deliberation of this committee, Madam Chair.
The motion is considered as the manifestation by the Honorable Alvarez.
Madam Chair.
The Honorable Rodriguez, then Garbin, then De Lima.
Thank you, Madam Chair. I'd like to ask propound questions to the endorser, the Honorable Jet Nisay. Are you aware that there is an international organization called the Interpol, International Police, Criminal Police Organization, which was created in 1956 by the United Nations, by the General Assembly in 1956, and the Philippines is an original founder and signatory of this convention.
Yes, Madam Chair.
And of course, you're aware that the ICC has issued a warrant, and it requested the Interpol, the international organization, wherein we are members, to cause the arrest of the former president in the Philippines.
Yes, Madam Chair.
So the arrest is not based on the order of the president or anybody in this country, but it is pursuant to an implementation which we are duty-bound to therefore cause the arrest of the former president because the ICC has issued a warrant of arrest. Would you agree with that?
Do you? Madam Chair, dapat po yung position natin dumaan sa judicial system muna natin.
But Rule 59 of the Rome Statute of the International Court of Justice precisely provides for the arrest. Now, you are saying, that's a good point, because you said that it should also go to the court. That is also provided in the Rome Statute. And that's why there's also an issue on the rendition, because you stated here surrender. And of course, that's another issue. The first issue is the arrest. And clearly, the arrest is legal because it is upon our compliance of international law. Now, so the rendition, there are many views. And would you therefore agree that this particular issue is now pending in the Supreme Court, Congressman Nisay, because in the cases of, first, in the matter of, for the record, Madam Chair, in the matter of the petition for habeas corpus of Rodrigo Roa Duterte, petitioner Sebastian Z. Duterte, against the Honorable Lucas Bersamin, it is GR number, to put on record, the number, Madam Chair, is 278-73. And the other cases brought about by Veronica Duterte and also by Paulo Duterte, which in seriatim was also filed, then you agree that there is a pending case, and the main prayer of this particular cases, of these cases, are the following. It is stated here in the prayer. It is questioning the arrest and the surrender of the president to the International Court of Justice. Are you aware of that, International Criminal Court?
Yes, Madam Chair.
So therefore, with your answers, the Honorable Jet Nisay, then there is no kidnapping, because kidnapping means that there is no power of any person to be able to get into detention a person. And therefore, in this case, there's a warrant of arrest, and it was executed by our country, which is a signatory to the Rome Statute. And as to the issue of rendition, surrender, it is already the Supreme Court, and according to our rules of judice, we cannot discuss here cases the Supreme Court. Whatever we say here, once the Supreme Court comes out with a decision on these cases, on the validity of the arrest, of the bringing of the president, the rendition to the ICC, is a matter already in the Supreme Court. You agree with that, Mr. Jet Nisay? These are facts. You are stating here that there is kidnapping, there is illegal surrender, but the facts are that precisely Interpol, arrest. Rendition, the issue is in the Supreme Court. Would you agree with that?
Yes, Madam Chair.
Thank you.
I wish to remind the House members, the committee members, that if you can express your point by way of manifestation instead of question, we will encourage that. That is in the interest of time because we have 4 other offenses to deliberate upon. Now we will move to the recognition of the Honorable Garbin.
Thank you, Madam Chair.
Let us all be reminded that this is just preliminary. The endorser will be very much ready to answer all the exhaustive questions when we reach that hearing proper of our proceedings. So kindly limit our question, and if you can translate it into manifestation, that would save a lot of time. Thank you.
Madam Chair, on the first allegation, culpable violation of the Constitution, the endorser alleged that, or avers that, he based his allegations grounded primarily on media reports and public documentary. Culpable violation of the Constitution in the records of the deliberation of the Constitutional Commission defined as willful and intentional violation of the Constitution. Commissioner Maambong, I'm referring to the records of the Constitutional Commission, stated that culpable violation of the Constitution means willful and intentional violation of the Constitution and not violation committed unintentionally or involuntarily or in good faith or through an honest mistake of judgment. How can we decide on sufficiency, on substance, grounded on mere allegations, primarily based on media reports and public documentary? In fact, I refer to the case referred and mentioned by Congressman Rufus Rodriguez in the case of petition for writ of habeas corpus of Rodrigo Roa Duterte, still pending before the Supreme Court. And the House, and that is precisely the reason why there is a pending case before the Supreme Court regarding the legality of the arrest. And to render it illegal at this point and attribute the same to the President is still premature and baseless, Madam Chair. The House will then be placed in a very awkward situation wherein a President is being tried for a supposed illegal arrest when the same is subsequently ruled as legal. So I therefore submit that manifestation, Madam Chair. Thank you.
Madam
Thank
Chair,
you.
point of order,
Thank
Madam
you.
Chair.
Before we proceed, we've heard a lot of opinions, comments, and even questions from the members with respect to the first offense. So it is the intention of the chair to limit the succeeding members who will be asking on this offense so that we can move to the next offense. Nonetheless, we recognize the Honorable SDML Lawrence Defensor.
Madam Chair, just a point of order on the way we proceed with the deliberations. Let's just address our manifestations as the complaint alleges. We don't have to interrogate the endorser. The Honorable Nisay is not the complainant. Let's just make manifestations and simply state the complaint alleges the following and state our manifestation. Thank you, Madam Chair.
We encourage the committee members to follow the suggestion of the Honorable SDML Lawrence Defensor. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Pursuant to the instruction of the Chair and has already been suggested, let me manifest that on ground 1, there's no impeachable offense. We all know that there's no kidnapping. Second, the arrest was by virtue of an arrest warrant issued by the International Criminal Court because of an offense which had been allegedly committed when the Philippines was still a member of the ICC. And it was coursed through the Interpol. So, and let me point out, with all due respect, looking at all the complaints, there's actually no narration of facts. It just stated and went to the arguments. So, I am forced to, of course, manifest that the respondent did not commit any betrayal of trust or culpable violation of the Constitution with respect to allegation number 1. I so submit.
Thank you, Vice Chair Dumogan. With that, the Chair wishes to move to the second offense. Please allow the Chair to read. Respondent is a drug addict whose condition impairs his judgment and leadership. This is anchored on the ground of culpable violation of the Constitution and betrayal of public trust. At this juncture, we elicit the manifestations, preferably manifestations, of the committee members with respect to its sufficiency in substance.
Madam Chair,
The Honorable Agbas is recognized.
with respect to allegation number 2, although the complaint claims the respondent is unfit to serve as president due to drug addiction, it fails to allege the ultimate facts showing how this alleged personal condition translated into any impeachable act. It does not narrate when the alleged use occurred, how it was committed, or how it affected any official function. It simply concludes that the respondent is unfit to serve without providing the facts required to demonstrate an impeachable offense. Further, no factual narration of an official decision, directive, or exercise of presidential power impaired by, connected to, or caused by the alleged addiction. That's all, Madam Chair.
Any other member who wishes to make a manifestation on this?
Madam Chair, may I be recognized?
The Honorable Barbers, and then De Lima, and then Suntay. One after the other. You are recognized, Honorable Barbers.
Thank you, Madam Chair. A manifestation. One of the grounds stated in the impeachment complaint filed by Attorney De Jesus and endorsed by Representative Lisay is the allegation that the respondent is a drug addict whose condition impairs his judgment and leadership. The complainant asserted that the respondent is unfit to serve as president due to drug addiction. He further alleged in his complaint that the respondent's refusal to submit to drug test conclusively demonstrate his disregard for transparency and accountability, and concluded that the respondent's silence and evasion confirmed the public suspicion and betrayed the trust of the nation he swore to serve. Madam Chair, let me point out that this assertion in the complaint was based solely on the alleged statements of the sister of the respondent, Senator Amy Marcos. The complainant attached copies of news articles containing reports on such statements of Senator Amy Marcos and forms part of the complaint. Under the rules of procedure and in impeachment proceedings, the requirement of sufficiency in substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. There is no evidence or authenticated records submitted by the complainant that will support his allegation that the respondent is actually using illegal drugs. The complainant did not even mention that he has personal knowledge of the drug addiction of the respondent. Such allegation of illegal drug use by respondent, which was reportedly stated by another person and not the one who filed the complaint, is mere hearsay and lack probative value. On the other assertions by complainant that the respondent is unfit to serve as president due to drug addiction and that his refusal to submit to drug test are all speculative. and without any factual basis. I humbly submit, Madam Chair, that the ground for impeachment of the respondent on his alleged drug addiction that impairs his judgment and leadership is insufficient in substance. Thank you, Madam Chair.
The manifestation of the Honorable Barbers is noted by the committee. The Honorable De Lima.
Thank you, Madam Chair. This is actually supplementary or complementary to the manifestation made or the opinion made by the Honorable Representative Barbers. The ultimate general ground, betrayal of public trust. The specific allegation is alleged drug addiction of the President. And I would point out to certain sub-allegations and refute their insufficiency. Allegation number one, sub-allegation number one, there are serious accusations that PBBM is a drug addict. The offense alluded for this ground is drug addiction. Stating that there are accusations do not constitute factual allegations of the addiction. This ground presupposes that because PBBM is an addict or an alleged addict, he is unfit to be president. However, unfitness per se is not a ground for impeachment. And even when considered as constituting basis for betrayal of public trust, the statements in this ground do not sufficiently establish allegations on how specific presidential acts were impaired by PBBM's addiction, assuming the addiction to be true. Second sub-allegation, Senator Amy, the sister, admitted or alleged or announced that PBBM is a drug addict. Again, this is not a factual allegation, but a conclusion that because Senator Amy admitted or announced that PBBM is an addict, then he must be an addict. The most that can be made out of this ground is that there was betrayal of the public trust because of PBBM's failure to disclose his addiction. However, the recital of allegations to this ground is still insufficient in terms of showing the nexus. Kasi yun po importante. The nexus between the facts raised or alleged and betrayal of public trust. Public accusations of PBBM's addiction, Senator Imy's claim of PBBM's addiction, PBBM's refusal to submit to a drug test, and his silence on accusations of being an addict still do not constitute the factual allegations necessary to satisfy the legal exercise in the formulation of causes of action that, assuming that they were all true, they establish betrayal of trust. Another sub-allegation is the PBBM is a drug addict because he refuses to submit to a drug test. Again, this is a conclusion and not a factual allegation. Nasabi ko na rin po, that kind of an allegation is still insufficient. The fact that he refuses to submit to a drug test. Another is by being silent. Sabi sa complaint. By being silent on his drug addiction, PBBM betrayed the public trust. For me, Madam Chair, this is a non sequitur conclusion and not a factual allegation. Because the ground must not only state a categorical allegation that PBBM is a drug addict and that this impairs the performance of his mandate, but must also include a recital of the alleged acts, events, and incidents that support the same. How do they say, or how do they know, or why do they claim that it impairs his judgment? So that's again my view. Again, this second ground is insufficient in substance. I so submit. Thank you, Madam Chair.
Manifestation is noted by the committee. The Honorable Suntay.
Thank you, Madam Chair. On the second ground, alleged unfitness due to drug addiction, President Marcos is alleged to be a long-time user of illegal drugs. Drug use allegedly renders him manifestly unfit to discharge his presidential powers. The evidence presented were public statements attributed to Senator Amy Marcos, news articles, opinion commentaries, and medical articles on the effect of cocaine use. Thus, the legal theory asserted is that drug addiction impaired his judgment to discharge his presidential duties. However, this is a general conclusion because there was actually no narration of which of the presidential actions or judgment was impaired due to the alleged drug addiction. There was also no medical evidence presented, no drug test results. So the allegations were merely limited. The evidence of drug use were merely limited to media reporting and political statements made by Senator Amy Marcos. In Philippine impeachment jurisprudence, it has never recognized personal health allegations without proof of impeachable offense, of the impeachable offense. And with regards to the second complaint, there were actually no general, there were actually no evidence, actual evidence presented to justify the allegations.
You're referring to the second offense?
Yes, with regards to the second offense.
Thank you.
Madam Chair.
Honorable Garbin first, then Honorable Po. Honorable Garbin, you are recognized.
Thank you, Madam Chair. On the alleged drug addiction and moral unfitness, the key factual allegations by the complainants were the President is accused of being a long-time user of illegal drugs, including cocaine, and central reliance is placed on public statements by Senator Amy Marcos, the President's sister, alleging or acknowledging his alleged decades-long struggle with illegal drug use. And the legal framing of the complainant is that not framed on any criminal accusation, and it is used to support the moral unfitness, the impaired judgment, and the betrayal of public trust. The allegation that the President is a drug addict is insufficient in substance. It is unsupported by competent evidence, such as medical findings, sworn admissions, or official investigation on record, and rests largely on hearsay and public speculation. Absent verified and authoritative proof showing impairment in office or misconduct indirectly related to the exercise of presidential functions, such allegation cannot establish impeachable offense and should not be given weight, Madam Chair. Thank you.
The manifestation is noted. We will be limiting the manifestations and comments with respect to the second offense to the two last members. These are Kong Po and Kong Lord and Suwan. We encourage the other members to participate in the discussion of the succeeding offenses.
Madam Chair, can you add me for the second charge? Very short
right.
manifestation.
Now we recognize the Honorable Po.
I'll make mine as quick as possible so that we can accommodate Kong Rufus. So with regards to my manifestation, Madam Chair, what we've established through everyone who has manifested ahead of me is that there's no record of illegal drug abuse. That is clear. What we know for a fact and what is actually on record is that on November 2021, there was a negative drug test that was attested to at St. Luke's. And further, on May 2024, there was actually a Senate hearing in which one drug analyst, Jeresa Reyes, and laboratory head Dr. Cecilia Lim confirmed that the President tested negative specifically for cocaine. So while there is no existing record of any drug abuse, the President has on 2 occasions proven that he is not a drug user. I submit that to the record so that we can make a objective decision on the substance of the second ground.
The manifestation is noted. The Honorable Lord and Suwan.
Madam Chair, this is my manifestation. So there is an allegation in the complaint that there was an admission by Senator Amy Marcos that the President used drugs. However, this admission cannot be considered because of Rule 7, Section 17 of our own House rules regarding impeachment, which states that the rules of court apply suppletorily. We should consider Rule 130, Section 28 of the Rules of Court regarding the res inter alios acta rule, which merely states that an act of one cannot prejudice another, meaning that the so-called admission of Senator Amy cannot prejudice the President, which means that the so-called admission has become irrelevant and cannot be considered as one of the bases for sustaining sufficiency in substance.
Our last committee members to comment on this are the Honorable Rodriguez and then Honorable Vice Chair Dumogan. We encourage the rest of the members to participate in deliberating the succeeding other offenses. The Honorable Rodriguez.
Thank you, Madam Chair. This is a clear example of not a recital of facts, but a conclusion of fact not based on any evidence. There is no evidence that the President is using drugs. Only statements of some persons. And then this particular allegation, being a mere conclusion, does not connect to any of the 6 grounds of impeachable offenses. And so therefore, clearly, this particular second act complained of has certainly it's not sufficient in substance. Thank you, Madam Chair.
Thank you. The manifestation is noted. Vice Chair Dumogan.
Thank you, Madam Chair. In addition to what already been said, which I fully agree, reliance on newspaper clippings is not sufficient